Good afternoon, everyone, or good morning for those on the West Coast. This is Jonathan Pompan at Venable in Washington, D.C., and welcome to the Venable webinar, CFPB Outlook 2015. I'm here in Washington alongside my colleagues, Allison Baker.
Good morning. How are you?
Randy Shaheen.
Good morning.
Andrew Biggert.
Hello, everyone.
And Alexandra McGarris.
Hello.
And before we get into the discussion, Allison has a few administrative matters to cover.
Good afternoon, good morning. This presentation today is being recorded and will be available at www.venable.com/CFPB later this week. We're very pleased to take your questions and get your observations about the CFPB during our presentation. There are on-screen prompts that you should follow in order to enable you to submit those questions. And please feel free to send them in, and we'll take them as we get them and respond accordingly. Thank you so much for joining us.
But of course, please, folks, no confidential information, and to the extent you have specific questions, we'd be glad to take them. We'll try to work them in during the course of the conversation. We'll go over our agenda lineup in just a moment. But first, there's also going to be some CLE involved here too, so we have some CLE announcements.
So CLE is available for this program. At the end of the webinar, I will announce the code, and a certificate will then be sent by email to you.
Thanks, Alex and Allison. And again, welcome everyone to today's webinar, CFPB Outlook 2015. So Happy New Year. And the big question, Andrew, Randy, Alex, and Allison, is now that we're getting into the start of the year and everybody's sort of back at the office after essentially that 2-week break in December, folks are asking increasingly us, and in fact we're all talking to each other about what we can expect in 2015. And while of course that answer depends on who's asking, and in some cases certainly a lot, or sometimes it's a little, in short, at the CFPB at least, it's more exams, supervision, enforcement, rules, and without question, scrutiny. Some people might say that's more of the same, but it's actually very much evolving. And after 3.5 years of the Bureau being up and running, things are very much moving on all fronts, not just supervision or not just exams, not just rulemaking, but really all of them. So we'll be talking about today all that growth at the agency and the trajectory ever since it was created, and it's already left a stamp in a number of areas that help us understand where it's headed.
Yeah, this is Andrew for everyone, and I think you can really see that in looking at the different rules and rulemakings that the Bureau has engaged in the past and is currently working through. Things like debt collection, prepaid financial products and services, the expected proposed rule to come out for small dollar or payday lending, as it's often called. And at least I think from the rulemaking perspective, as we'll get into later in the slides, you'll see a lot of common themes that start to get repeated through the supervision and the enforcement side as well. And so we're looking forward to kind of going through all of that today.
Thanks, Andrew. And if you look, really some of the very first enforcement actions that the Bureau brought involved scrutinizing advertising marketing practices for some of the credit card add-on products under the UDAP authority. So, that's kind of how they started, and I think we expect that's just going to continue to ramp up.
That's right, and we'll just have to stay tuned. And of course, with congressional Republicans now in control of Congress, we expect that they will do their best to probably thwart new rules and limit the power of the CFPB. And so with the clock ticking on the president's second term in office, this will really be very important for how the CFPB looks going forward.
Yeah, it sure will be, Alex. And with the 114th Congress convening yesterday or earlier this week, there's now the largest majority since 1928 in the House for Republicans, and obviously pretty close, but not exactly the supermajority in the Senate that's needed to enact total change. But nonetheless, all of the issues that have been brought up over the last 3.5 years, or really 4 since the passage of Dodd-Frank related to the CFPB, are going to continue to be discussed and debated in Congress, and there's always going to be the potential for some one-off amendments related to substantive statutes that the CFPB enforces, as well as also, the continued movement for reform. So all that and more will be covered in today's discussion. For folks listening in, again, we welcome your questions at any time. We'll try to work those in as best we can within the categories that we're going to cover. And of course, at the end, we'll leave some time for observations and Q&A. So with all that, the big question is, of course, what does this all mean for providers of consumer financial products and services? So now let's take a look at CFPB supervision.
So when Dodd-Frank passed, it received a lot of attention and caused reverberations in consumer financial markets. And among the most significant impacts of the law was the establishment of the CFPB supervision program, which is now in its 4th year. And so we'll start there. So turn to the next slide. As many of you likely know all too well, the CFPB supervises both banks and credit unions and non-banks, regardless of size, in certain specific markets, including mortgage companies, payday lenders, and private education lenders. The Bureau also may supervise larger participants in other non-bank markets as it defines by rule. And to date, the CFPB has issued rules defining larger participants in the consumer reporting market, debt collection, student loan servicing, and international money transfers market. And while the supervision of banks wasn't anything new, the supervision of non-banks has really dramatically changed the compliance model for companies in these markets. In 2014, the CFPB conducted about 150 exams. And so looking at the map, you see, it's got 4 offices that are, splits up the map, 4 offices that in terms of the supervision program. And as you'll see, it's the breadth and scope of its authority and its ability to supervise has really, really changed the landscape. And of course, we know that through supervision it has, but it's doing almost as much, if not more, through supervision. Looking at the next slide, really quickly, the supervision program is run out of the Supervision, Enforcement, and Fair Lending Division. The fact that supervision and enforcement are housed under the same roof certainly is not a coincidence, and has unsurprisingly been controversial. Bureau would call a lot of slack at the beginning of its program for having enforcement attorneys physically present on exams, which of course unnerved a lot of the companies that were under exam. And after some pushback from industry, the CFPB decided to remove the attorneys from the exams, but made very clear that enforcement continues to coordinate very closely with examiners off-site. And so for many non-banks, this supervisory role has probably had the most direct and significant impact, because for the first time, they're subject to regular, comprehensive examinations by a federal regulator. CFPB exams generally include on-site visits by an exam team, during which the company's employees are interviewed, and the examiners are observing operations to determine whether the company's conduct and practices comply with the law, followed by the issuance of a report and findings and a rating. And so looking at the next slide, we lay out the 4 phases of an exam. We could probably spend an entire hour just discussing how an examination unfolds and what steps a company under exam should take to prepare for each. But just very quickly, first, a company will receive notification that it will be subject to a supervisory exam, and the examiners also send a request for information and documents covering the full span of business practices, which they then receive and review and use to conduct their scoping and planning of the on-site portion of the exam. And then of course, the examiners ring the doorbell and actually set up shop at a company's offices or facilities. And that's where kind of the most intense part of the examination happens. The examiners are present on site. They are interviewing employees and managers. They're observing practices or sitting, looking over your shoulder, and actually, observing the business practices, regular course of business, and making determinations about the company's practices. In the third phase, examiners leave, they go back and huddle and come up with findings. First, preliminary findings, which are communicated to the company, and there should theoretically be a back and forth conversation about the findings and can supplement information that maybe was missed during the on-site portion. But ultimately, when that all wraps up, there will be a final report and findings and a rating. And then depending on what those findings and rating are, there could be remedial action required of the company. Oftentimes it's non-public, just you have to take X, Y, and Z steps, and the examining team works with the company in the coming months to make sure that everything's implemented. Oftentimes it could also result in in a referral to enforcement, which we'll get into. And then after that exam is completed, there's ongoing monitoring, again, depending on what the findings were.
And with that base, Alex, and that terrific introduction to the process of exams, we've certainly seen it Venable and worked with a number of clients that have gone through this process through all four squares. And the objectives so far have always been fairly consistent, but how that plays out has been different depending on the entity and really the level of preparation that folks do on the front end as well as the level of engagement. What have you seen in your work?
Well, that's right. Of course, and we'll get to kind of some tips in a few slides, but generally, if your company is subject to supervisory authority, CFPB supervisory authority, it's a question of not if but when. The CFPB examiners are going to come at some point and examine your company, and so the best prepared companies usually can get through an exam pretty seamlessly without huge disruption to their business practices, and also most importantly with a great outcome. But it really is about having compliance management systems in place and a plan for having the examiners on site and providing information and showing your company's practices in the best light. And just looking at the CFPB examination objectives on the screen, these are the CFPB's self-identified objectives. And looking at the first one, you see to assess the quality of the entity's compliance management systems. We cannot stress enough how important a CMS is to the CFPB. That is something that in every exam, it's a standalone section. There is a module in the examination manual just on compliance systems, and they're looking at policies and procedures and structure in place to ensure compliance. And so that not only is looked at in the exam, but also if you have it, it helps you. It's the best preparation for an exam and ensures the best outcome. A second objective of the supervision program, interestingly, is to identify acts or practices that materially increase the risk of violations. And so they're not just looking for conduct or practices that actually violate the law, but practices that may increase the risk in violations of the law. And that's very different type of analysis that's being done there, and has caught a lot of companies off guard.
That precautionary principle is really inherent in a lot of what the CFPB has been doing, and Allison, in the exam setting, and also the enforcement setting, which we'll talk a little bit more about in greater detail in a bit, the idea that there could be harm is almost as important and significant and hurtful for a company as actual consumer harm. It's very much a precautionary principle concept.
That's absolutely right. I mean, the mind's eye of the CFPB is the mind's eye of the consumer. And so what the CFPB is looking at is, number one, as Jonathan and Alex have very eloquently stated, actual harm to consumers. But they're also looking at the question of how are you managing your system so that at a company level you are decreasing the probability that a consumer could be harmed at some point in the future. And the idea here is that there's some concept of preemptive action that's expected of companies once they're alerted to the possibility that a particular component of their CMS might be vulnerable to consumer injury. And so that's really critical. And I will note this, some of this is also industry specific. There are definitely some industries that I think are more susceptible to scrutiny in this regard than others, particularly industries that are involved in business lines that don't necessarily involve the same aspect of consumer choice, such as servicing or collections of debt. The idea from the Bureau's perspective is that consumers don't go out actively and choose who their mortgage servicer is going to be or who's going to collect their debt. And so companies in that space have to be particularly vigilant about making sure that their CMS, their compliance management systems, are able to not only deal with actual or potential consumer injury, but the possibility that some aspect of their conduct could give rise to consumer injury in the future. That's very, very, very mission critical for the CFPB's examination program.
Yeah, and I think one of the aspects of that that is really important is that the CMS program be focused on consumer complaints that either the company itself is receiving or that the company might be seeing out in the media or through other enforcement actions through the Bureau's complaint database, for example. And that issue of the consumer complaint and tying that into your CMS, it's kind of a theme that you also probably see with rulemaking priorities that the Bureau has in terms of what are the consumers actually voicing as the issues that are important to them.
I couldn't agree more with you, Andrew. It can't be said enough and underscored enough that the way a company handles consumer complaints, responds to consumer complaints, processes those complaints, categorizes those complaints, and how high up in the company's infrastructure those complaints go, especially ones that are significant, is mission critical to the CFPB. And the CFPB's examination of both banks, large banks, and non-banks focuses on that point a great deal, and that is a very marked distinction from any other supervision program out there. The Bureau really, really, really cares a lot about the way companies handle consumer complaints per its database and others. And so
perception's really almost more important than the reality. You could have just a small number of complaints as a percentage of overall consumer transactions, and the Bureau would still say that any complaint could be significant depending on what the substance of it is, or just the fact that there's even a complaint sometimes, whether or not it's bona fide or not, whether it's been resolved, it may be symptomatic of something else. There's really a lurching at the perception, and again, it's this precautionary principle. Now, Alex, there's also been obviously one of the objectives is to gather facts to help determine whether the entity itself is actually violating substantive, federal consumer financial laws. But that's even played out a little differently at the Bureau than it may in other circumstances, just based on the Bureau's interpretation of consumer financial laws and what they mean. Is that right? We've seen that a bit, and can you gloss a little bit on that?
Sure. I mean, we've had multiple situations where after the exam team left the premises and came back with their either preliminary findings or ultimate findings, that they've identified what they say violations of the law, where the company just fundamentally disagrees with the examiner's interpretation of the law. I mean, the facts, they get the facts right, they understand the business practice and how it works, but the way that the examiners are interpreting the law is completely inconsistent with other previous guidance from the CFPB or other agencies and case law. And so there, it's really difficult to to prepare for something like that without, because you just really are unsure as to how far and how broad the CFPB may potentially interpret a regulation.
Alex, this is Allison. You bring up a really interesting point. The CFPB's Office of Supervision is actually divided into two sub-offices, the Policy Office and the Implementation Office. And the Policy Office is really the part at the Bureau that's responsible for looking out across the country and trying to figure out how to consistently apply consumer financial laws, including the UDAP provisions that the Bureau enforces. And it's interesting to hear your experience, because I suspect that, and I know that from both speaking with clients and from speaking with other practitioners in the field, that there's often a sense of frustration that the Bureau's interpretation of a law is either inconsistent with its other interpretations or inconsistent with prior precedent. And I think it will be interesting to see how 2015, the Policy Shop, which is staffed by some very smart, talented people, continues to kind of roll out and smooth its edges, if you will, of its program. Because some of that, I think, is frankly a function of the Bureau being new, and some of that, I think, is a function of the Bureau for the first time examining a whole group of non-banks that have previously not been examined for compliance with these laws on the federal level. And so your experience is an interesting one, and certainly one that, I think conforms to what a lot of other people have observed and experienced as well. And it'll be curious to see how I think that will actually be a big issue in 15, which is really starting to render some type of consistency across the country and sector-specific consistency as well.
Yeah, and Allison, the question, to some extent, what we've observed is the Bureau has been quite aspirational in what they would like the law to be. The question will be will the other, supervision and policy shops and in the regulatory rulemakings, will they catch up with the aspirations of folks in the exams and on enforcement, or will they be a modulating effect? And I think we could probably take bets on which direction things will go. But there's certainly been overall this aspirational concept, whether it's situations where there's divides amongst the circuits in the law with respect to, particularly like in areas of debt collection and other places where there's amicus briefs signaling what the Bureau would like the law to be. It may not be what the law is, but it is what they're enforcing against, almost in advance of there being court rulings or regulatory rulemakings.
Yeah, Jonathan, you raised an interesting point along with what Allison was saying, and I'd like to kind of hear Alex's kind of day-to-day observations from having gone through some of these exams with clients. How do you help a client determine when they get a matter requiring attention to kind of either push back on it because they feel that it's not established law, or to make the decision that they're going to voluntarily change their practices as part of their response to try to address and work with the Bureau through different issues?
Yeah, so Andrew is referencing matter requiring attention. We mentioned in the previous slide that at the kind of end of an exam, there's a final report, and oftentimes if there has been a negative finding, there will be a list of matters requiring attention, essentially a roadmap telling the company what changes they need to make per the examiner's determinations, conclusions. And we have faced a situation where the matters requiring attention sought a change that the company, and counsel did not feel like was necessary in order to be compliant with the law. And it is a difficult place to be if you're the company, because on the one hand, obviously, your regulator is telling you that they think this is how things need to be in order to be compliant, but also, unlike in an enforcement context with supervision, this is a long-term relationship. I mean, the CFPB will be supervising you regularly. You will have a relationship with this exam team or with the supervision program for a very long time, and so it's always the best practice to have a very good, robust, and transparent relationship with the regulator. And so you oftentimes, don't want to push back if it's not necessary, either from a business perspective or from a legal exposure perspective, and just, kind of work with the exam team to, incorporate the recommendations and changes they make, while, holding a fine, strong line that, we don't think that the way we were doing it was a violation of the law. And, in our experience, where you can have those conversations with the examiners, but we've also had situations where we've just said, we absolutely cannot make that change, and show us where where it says that this is a violation, and kind of made it a little bit more adversarial.
And Alex, that level of engagement is really important, up front. I mean, exams can take months, but the situation where there is a disagreement is one where if that disagreement is sort of held back until the end, until there's a report and matters requiring attention, it may very well just be too late. And then you get to the appeals process, which in and of itself is a bit of a black box, right?
Allison, go ahead, please.
No, I was just going to say, you bring up a really interesting point, you and Jonathan, about how do you kind of walk the line between complying, having a nice cordial relationship, but not necessarily conceding an area of the law. And I think it's fascinating because ultimately, I think what's going to happen is a lot of the arguments that get made in the supervisory context by the CFPB are going to go unchallenged. For the precise reasons that you've just laid out, because there isn't necessarily a situation that's going to arise where somebody actually affirmatively says, not only don't I agree with your view of this this provision of X law or regulation, CFPB, but I'm going to challenge you on it and not provide you with this information, and then the CFPB ultimately has to make a decision about how it's going to compel that information. I don't see that happening too often because, as a practical matter, as you said, people have long-term relationships in mind, and they have to maintain those. And so a lot of the law and a lot of the rules and a lot of the kind of, expanding this area of the law is going to happen in supervision. And it's going to happen in a way that isn't necessarily as public as an enforcement action, but in many ways is more potent because it's not susceptible to challenges in court the same way. And I don't know what your views are on that, Alex, but that's been my observation for the last few years.
I think the supervision program is in its fourth year, and for many markets, less than a year or 2 years. And I think you'll see that the exam teams will be increasingly more confident and comfortable, and then accordingly, hold things less close to the vest. I mean, unfortunately, the last couple of years, we've had a lot of frustrating experiences where we really couldn't get the level of information and transparency from the examiners to really understand what exactly do they see as the problem. Oftentimes, the findings come back and they're painted in a pretty broad brush, but have really dramatic consequences for the company. And so the company, of course, wants to comply and make the changes necessary to comply, but with minimal impact. And so that level of detailed conversation where if we make this tweak, will that meet your expectations, or do we have to do a huge overhaul of a practice? In my experience, has not really been happening. But I suspect that it is a consequence of just the newness of the program and the bureau, and increasingly you'll see the exam teams act more the way the prudential exam supervision regulators have been acting, where it's a closer relationship and it's an ongoing conversation, not just the 2 months that they're on site. So hopefully we'll see that in the coming years.
Yeah, and a lot of this is not self-executing. It sort of takes two to tango. So if a company does put up a bit of opposition, a bit of pushback, it can go a long way. I mean, ultimately, there is law and facts involved here, and there's, one would say that it should not be purely based on aspiration, but really grounded in the law. And as a result of that, there is a process built in here. Allison, I think you're right that there is a lot that's being done where folks are sort of going along to get along. But on the other hand, in 2015, we're likely to start to see the results of folks that have not necessarily all gone along to get along, but rather taken a principled and reasonable stance on particular positions. And we're already seeing on the supervision front, and we're likely to see, in 2015, a lot more of what the Bureau's thinking and finding on the supervisory front, in part through these supervisory highlights that the Bureau has been putting out. They put out 5 editions of these findings. In some cases, they're broad brushstrokes, but in some cases they're quite nuanced and connected directly to eventual enforcement actions. And that's also a bit of the question is can somebody make corrective action without getting nailed for an enforcement action retroactively for acts and practices that occurred in some cases before the Bureau even existed? And 2015 is going to be that year where all of that comes to fruition, because we're starting to get to the tail end of first-round exams, first-round enforcement investigations, and the acts and practices that occurred in, let's say, 2008, 2009 are now starting to be really in the rearview mirror. And so it'll be interesting to see how that all comes to a head. We've talked a lot about CMS, and CMS findings have been really key at the Bureau. That seems to be something that has been front and center. Alex, the compliance management system findings consistently in all of the CFPB's supervisory highlights have been reiterated. As Andrew mentioned before, it's connecting the dots between complaints and what consumers are saying generally, even what's happening in the rulemakings, and then linking that all in. But what have you seen essentially out in the field? CMS probably the most important of all, irrespective of the substantive requirements.
And CMS is compliance management system.
Right. I mean, the CMS certainly is the common denominator, regardless of what market you're in, what type of consumer financial products and services you sell and engage in. If you have a strong CMS that's able to identify the rules and statutes that your company's practices are subject to, that can implement them and can test to see if, to test for compliance and take remedial action, then, regardless of the specific, regulation or violations observed, the CMS will take care of, I'm not going to put a percentage, but a large portion of the risk, right? Of course, there's always the possibility that you could have the strongest CMS and still have an issue of noncompliance. But the best way to mitigate risk is to have a strong CMS, which is why I think the CFPB has emphasized it so much. And it seems to be working. The CFPB's last supervisory highlights published in the fall actually had a bit of good news for the first time. They reported seeing banks, and especially non-banks, increasing their resources dedicated to compliance, having more robust reporting structures and involving senior management and the board of directors more and more. And of course, I think the CFPB takes credit for that, and rightfully so. Companies have responded to the specter of being, of supervision, and have, dedicated more and more resources to the CMS.
And, and substantively, Allison, this has resulted in some cases, though, in direct enforcement actions being taken. And there's just a sampling on the screen, but there's real dollars involved in the result of an exam by supervision. And in most cases, these are practices that, occurred, if not at the early stages of the Bureau, in some cases even before the Bureau existed, which is also where there's a bit of a debate in terms of whether or not the Bureau's authority is retroactive. But nonetheless, when somebody's faced in a supervision examination setting, folks might settle and concede certain points. But, there's been a lot of dollars associated with this.
Yes, there has been, and there's kind of a few key issues here that I think are really important takeaways as the slide up on the screen shows. I mean, the first is that, whether or not enforcement attorneys attend examinations is frankly a little bit beside the point, because you can be sure that there are enforcement attorneys involved at different stages of an exam, especially if the examiners on the ground find something that they believe is a potential is a violation of a potential law or an actual law, and that violation is significant enough to give rise to a potential enforcement action. The second takeaway is that there's actually a process at the Bureau where you have folks from supervision, enforcement, and as relevant fair lending who sit around a table and say, look, we've seen these violations in the field, company X, company Y, company Z. Are these violations of the type that should be elevated to the Office of Enforcement for some public action? And often the case is yes. And the answer is yes in the mind's eye of the Bureau. And so you have these very large numbers coming out of findings that are a result of examinations. And I think the third takeaway, as Alex pointed out in the supervision bulletin that was issued in the fall of 2014, is that, look, these exams are yielding enforcement actions that are in turn resulting in large dollar numbers that are being assessed against companies for violations, and that's a deterrent. And that's the Bureau's way of kind of saying, look, don't even think about having a CMS that's inadequate. Don't even think about having inadequate training. Don't even think about having a complaint process that doesn't adequately respond to consumer complaints and elevate ones that are appropriate, because it's not enough that we're not going to simply just slap you on the wrist and keep it quiet. We're going to elevate this and make this public. And that's, of course, a very powerful thing, not just because dollars are involved, but because there's always attendant risk that goes with the publicity of an enforcement action. And so these are very, very, very significant developments. I think some of the most significant developments in the last 18 months of the Bureau are how the findings of exams have been informing the bringing of enforcement actions. And that will continue. That trend will continue and probably will increase in the next year or two. That's a prediction that I think we'll find to be the case as the offices of supervision and enforcement continue to work very closely together, and everyone's getting their sea legs because this is a new agency.
And so the lesson there really is to be engaged really upfront on that exam process.
Absolutely.
And be really mindful of the fact that anything done at the very early stages of the exam could have a material impact on not only the outcome of the exam, but potential enforcement efforts that the Bureau might take. And so, frequently we'll see situations where there's a question of how engaged one should be at the front end of an exam. Is it business as usual? In some cases, companies are used to due diligence exams by vendors or their service providers to financial institutions, regularly having people in their offices looking at things. And so there's often a tendency to think, well, it's just business as usual. It's just another tour and somebody asking 20 questions. But in fact, it may not be. It's going to have some consequences. And so getting legal and compliance and the risk folks all involved on the front end, and maybe outside counsel, can be very important to understand where you might land on the back end and have some potential to hopefully influence that process as well. We also have seen other supervisory activities of note. Without question, the Bureau is coordinating with states. They're working under the framework with the Conference of State Banking Supervisors, and in some cases, essentially doing joint exams in certain market categories where there's state licensing and supervision, particularly such as like in the debt collection market and others. They're, if not doing everything identically, certainly sharing resources and the manpower in terms of just collecting information. And again, what can't be underscored there is not only is there a level of communication, but that also, too, states in some cases are going to be looking at things differently than the Bureau. The Bureau is going to be looking at it from their lens, and states may be very much focused on obviously their particular state statutes and specific requirements. There's also been a lot of supervisory guidance released in recent examples include bulletins on credit card promotional offers, mortgage servicing transfers, and others. And then even just right before the holiday period, on the consumer reporting agencies, there was an announcement that the Bureau was collecting through essentially its examination authority information about furnishers and furnishing practices related to investigations of disputes. And that's a real interesting use of the supervisory process, is basically a data collection effort on other market participants. And the Bureau released not only a press release and some comments, but the actual template that was being used and sent to CRAs to collect information. And that is just one example. There may very well be, and certainly we've heard of other examples where in the supervisory process, the Bureau is trying to solicit information about other actors. So there is a level of even coordination and sort of strategy within the rubric using the tool of supervision to accomplish another goal.
You know, the Dodd-Frank Act to some extent contemplates this coordination and in fact mandates some of this coordination as well. So some of this is a function of resources, some of this is a function of statutory requirement, although nominally most of it is a function, I think, of resources.
And, you know, there's no doubt that the CFPB supervision apparatus is significant, and it's going to require companies to, and has required companies to do a lot. But, you know, what's been clear since the beginning, too, is that the CFPB is going to use its enforcement authority to enact, you know, policy as well as also, of course, identify harm to consumers and alleged violations of the law. You know, its authority is quite broad. There's no question that there is an ability for the Bureau to look at many different angles of a company and essentially do an exam through an investigation, through the enforcement office. The power is significant, but probably what's equally as significant is, you know, the way that exams can start, or rather enforcement investigations. There's lots of triggers. We've talked about the examination trigger, but there's also, you know, a lot of other tools that the CFPB uses to prioritize. And, you know, one that's been front and center recently has been certainly the complaint database, but, you know, media coverage and even, you know, whistleblowers could be the source of scrutiny. Now, the Bureau doesn't have an unlimited staff, but it does have a quite large enforcement office. And, you know, Allison, you know, when you were there, and certainly since then, they've collected quite a lot of money and forced a lot of restitution in recent years.
They have collected a lot of money, you know, billions of dollars, in fact, since the enforcement office started. And, of course, they've also collected a fair amount of civil money penalties. We have up on the screen $77 million in last year and $49 million the year before and $32 million the year before that. And, you know, the civil money penalty fund at the CFPB is markedly different from any other fund in the government because unlike most civil money penalties that regulatory agencies and enforcement agencies obtain, it does not go to the Treasury. It goes to what's called the 1017 fund. 1017 is the provision of the statute that regulates the fund. And the fund is essentially two things. Civil money penalties are used to pay any residual monies owed to victims of the alleged misconduct, and it's also money that goes to programs that are designed to enhance and support consumer education. And so the Bureau's use of civil money penalties is interesting because it's not just a deterrence, it's also something the Bureau sees as kind of further and directly helping those consumers who are victims of the alleged conduct the Bureau is seeking to enforce against.
A Robin Hood principle.
Similar to a Robin Hood principle of sorts. So I note that because I think it's a little bit different than what you often hear when you hear about CMPs. But yes, the CFPB has been very busy collecting restitution, which is essentially the Bureau's way of giving consumers back money that they would have received but for the alleged misconduct, putting them back in the place they would have been, some rough approximation, and of course civil money penalties. You know, one thing that I note about the CFPB, a lot of its enforcement actions are joint actions. They're either joint actions with other federal regulators, the Department of Justice or the FDIC or the Office of the Comptroller of Currency, or they're joint actions with state attorneys general. And we have seen a fair amount of that. And we will continue to see a fair amount of that, especially in certain sectors such as mortgage servicing, which has been very big and has resulted in some of the biggest restitution that the Bureau has sought and obtained. You know, some of the big cases that have come down, Ocwen and SunTrust in particular, were joint actions. They were actions with the Department of Justice, with some state attorneys general, and of course with the CFPB. And that trend will continue. The Office of Enforcement at the CFPB has very close relationships with folks at DOJ, both Main Justice as well as several U.S. attorneys' offices. It also has a lot of close working relationships with state attorneys general, both through the National Association of Attorneys General, but also just through individual relationships. And that joint effort is certainly going to, I think if not remain the same, it will probably increase over the coming year. So that's another trend that I think we'll be looking out for as we enter 15.
And we're going to see more sort of probably results of, again, of companies standing up and saying, whoa there, this is, we don't agree. Certainly there's some cases that are being litigated now, both related to the Bureau's jurisdiction and also some substantive consumer financial laws. There was also an action in 2014 that resolved itself that was in the administrative setting at the Bureau, where actually there wasn't some outcomes there that were relatively important with respect to sort of the powers of the Bureau related to retroactivity and some evolution of sort of what the policy concepts of how far the Bureau is going to push. But what we've seen so far is that the Bureau is not only apparently not afraid to litigate, but that they're going to push the envelope. They brought an enforcement action again just before the holidays against a telecom company that ostensibly the FTC had been doing work in that area against all of its competitors. And rather here now the Bureau is stepping in and looking at mobile cramming as a consumer financial product because there's, in their view, some lending involved with the way the payments are taken. So the Bureau is not afraid to sort of also not only flex its muscles, but really seems to be trying to stake out its territory and is not taking a conservative view.
I think all those things are correct. Two observations about enforcement in particular. One, it's not afraid to litigate. It has independent litigating authority, unlike certain other regulatory agencies. It can walk into district court in its own name with its own lawyers. A lot of the attorneys in the Office of Enforcement are Department of Justice alums, and they have a lot of prosecutorial experience, and they are very willing and able to use that. And I note that because it's not the case that they're scared of or frightened out by the concept of a trial or by going to court. The other thing I note is that the Bureau, I think, is starting to enter a phase where it is going to be actively trying to build out its UDAP authority, unfair, deceptive, and/or abusive acts and practices authority, through common law, through the making of doctrine, much as the FTC has done over the years in its Section 5 UDAP authority. And so I think some of the lawsuits we're seeing and some of the cases we're seeing are an effort to really build that out and kind of what are the contours of the UDAP doctrine that the Bureau will be enforcing for the years to come. And so I will not be surprised to see more cases get litigated or at least pursued in district court in the Bureau's effort to really build out its doctrine.
Now, on to rulemaking, sort of the other lever of the CFPB substantively. The Bureau, has not only had statutorily under Dodd-Frank a number of rulemakings under mortgage that have been, if not entirely wrapped up. Certainly a lot of progress was made in 2014 and even earlier. But in 2015 on the horizon, there are quite a few substantive and insignificant rulemakings for different markets that have yet to have substantive rules written for it at all, even if the FTC or others previously had jurisdiction. And then we also, Andrew, we're seeing too a number of areas that have also been targeted for by enforcement and the examination process too. So as you mentioned earlier, sort of rounding the edges and linking the two.
Yeah, that's absolutely right. I think the theme, maybe looking forward to 2015, is that there are a number of rulemakings out there for particular markets that haven't really been subject to direct rulemaking type regulation before. And so it's going to be interesting to see how those rulemakings shake out, the impact on industry in particular. But just starting here with the first slide, we have up a copy of the CFPB's rulemaking agenda that it issued in the fall of 2014. This just kind of goes to show you the breadth of the different issues that the Bureau has on its rulemaking plate. Covers a lot of different issues and a lot of different stages of rulemakings. You've got stuff announced proposed rules. You've got rules that have been proposed that are still out for comment. You've got some rules that are being finalized essentially as we speak as well. And we'll spend some time over the next few slides highlighting really some of the upcoming rulemakings, the big ones, things like prepaid financial products and services, talking about things like debt collection and payday lending or small dollar loans as well. And I think, sometimes maybe the issue of rulemaking can get lost a little bit in the publicity, not always as splashy as a big enforcement action, but this is certainly an area where the Bureau can radically change the way an industry operates, maybe not quickly, but when it gets there, very profoundly.
And it can do that too, also using the supervisory lever through its examination process once these rules are in place. Like for instance, in the debt collection market, where previously that sort of authority and the major action was at the Federal Trade Commission, all they had was the enforcement lever. They didn't have the exam lever, right? So, Andrew, what you're seeing too in all of these is the overlap between exam and supervision and the rulemaking.
Yeah. No, I mean, there's certainly an overlap between all these things. The issues that get identified through enforcement and supervision are going to help lead where rulemakings go in the future. And then coming back the other direction, where rulemakings end up, you're going to have supervision and examinations to enforce those rules and potentially examinations as well.
The way the Bureau operates, and you touched on something very accurate, is the rulemakings happen, but they don't happen in a vacuum. They happen in the context of others at the Bureau besides the folks writing the rules, who inform the way a rule gets thought about or the way the market is looked at. Is the market in the first instance susceptible to rulemaking? Number one. Number two, what is supervision seeing? Number three, what is enforcement seeing? Number four, is a rule going to be written so that enforcement can actually enforce the rule? Is it going to be written so that supervision can actually examine for compliance with the rule? All of those kind of preliminary ideas go into the rulemaking process, which is, sometimes why the rulemaking process extends itself out longer than expected. But it's also what you're talking about, which is this very interconnected dynamic between supervision, enforcement, and rulemaking. And I also add into that the market staff at the Bureau, which is the policy shop that's connected to the rulemaking shop, and they're very much the people on the ground looking at the markets and trying to understand how they operate and whether or not a rule is going to if a market is susceptible to rulemaking, if there's a problem in the market, and if a rule is going to actually solve that problem. And so all of this is a very dynamic process. And this agenda never emerges overnight. It emerges over a period of time. So everything you're saying, it all kind of connects up.
And, Andrew, you mentioned the proposed rule on prepaid accounts as being a significant one that's impending right now. It's out for comment, and there's a little less than, 90 days left on the cycle for comments there. That's something, as Allison mentioned, it has not just happened overnight. This has very much been in the works, and these issues that it's going to be addressing are issues that have been prevalent and manifested themselves in investigations that predate the CFPB related to disclosures to consumers and concerns about whether or not there's appropriate disclosures, as well as also in some cases just the sales and marketing practices. And Randy later is going to talk a little bit about the front end, the scrutiny of the front end marketing of consumer financial products and services really drives a lot. The proposed rule on prepaid accounts in many ways is going to address a lot of what has previously been a hodgepodge of different issues that folks have been bringing up over the years.
Yeah, no, I think that's a good point, and the prepaid rule is certainly a good example to kind of kick off the discussion here. Just to step back for a little bit of background, prepaid products are cards and other kinds of access devices that allow consumers to store money and funds that they can then use in different places, whether at stores, ATMs, things like that. They're among the fastest growing types of consumer products that are out there. Just to give you a couple of numbers in scope, prepaid cards grew from less than $1 billion in 2003 to nearly $65 billion in 2012. But it's an area that hasn't really been subject to a lot of specific regulation before. Of course, you've got Regulation E and Regulation Z for debit and credit cards. But outside of payroll cards and a few other areas, prepaid cards have not been directly the subject of rules. But what the CFPB is proposing here are specific protections going to the advertising and marketing of these kinds of products, what kind of disclosures are being provided to consumers so that they understand the risks and the fees, for example, that are tied to these kinds of products. What's interesting about this proposed rule is also the size of it. It was formally published in the Federal Register in December, but it had actually been posted online by the Bureau in November, and it was over 800 pages in its initial format.
Andrew, is that more than it should be? Isn't that a little much?
Well, I think those who had to read through it would probably say, yeah, it was a little much.
It's the first discretionary rule that the Bureau has ever written. So
and it also expanded upon what the proposed rule had been from earlier in 2012 by adding a lot of sections on credit aspects of prepaid cards, and so I think that added a lot of the length to it, certainly. And it's very broad. I mean, it's going to provide a lot of the same protections currently available under Reg E and Reg Z to prepaid cards. We don't have to go through all of these, but you can see them on the next slide. The type of error resolution protections, disclosures, making sure that if you're going to have a credit feature tied to one of these products, that you're doing the due diligence to know that the consumer has the ability to actually make those payments on the credit, et cetera.
And these are specific to prepaid accounts, but these concepts are the same types of concepts that the Bureau's looking at in other markets too. The ability to pay and the timing to repay particularly is something that anytime there's any lending or financial transaction, the Bureau seems to take a great interest in. Obviously disclosures is sort of a top of mind as well. And error resolution, again, that's a feature of Reg E and this particular rubric for prepaid accounts, and is inherently a topic, but it's also a topic that is relevant to other areas too. Error resolution and fraud and the security of consumer information, et cetera, and who has the risk? Is there consumer risk or is the risk on the institution? Are issues that the Bureau is looking at, really across all of the markets, not just prepaid accounts.
The strains of there's kind of a few themes here, and the prepaid card rule is, as we were saying, the first discretionary rule. So it's the first rule the Bureau has promulgated that was not required under the Dodd-Frank Act. All the other rules were either required under the Dodd-Frank Act because of statutory requirements for the mortgage industry, or their larger participant rulemakings, which define the scope of their supervision authority. So this is truly the first discretionary rule, which is probably one of the reasons why it's so long. But it also picks up on a lot of these repeat themes: ability to pay, error resolution. So some of these things that we keep seeing over and over again in different contexts, not just rulemaking, but in supervision and enforcement. And I think it's a fascinating study in how the Bureau will likely address a lot of its rulemakings in the future, all of which will be, or many of which will be, discretionary.
Yeah, and one of those is the automobile financing market, larger participant. Now that very much early stages, it's not necessarily a substantive law, but it will be a market that they're focused on. And so, early stage is first let's start supervising and do some exams, take a look, and then the next stage will be potentially some sort of substantive requirements, and whether or not they're actually in a rule or not, it almost perhaps is immaterial. Through the supervisory apparatus, the Bureau will be enacting policy changes there, and one only needs to look at some of these other rules, other enforcement matters, supervisory highlights, to get a sense for the tea leaves of what's going to be focused on.
I want to take a step back just for a moment, since we have it on the screen, and that's the proposed automobile financing market rule, which is the larger participant rulemaking. Just conceptually, the way larger participant rulemaking works is as follows. It's the Bureau's statutory ability to carve up certain non-bank markets and and make those non-bank markets fall within the supervision authority of the CFPB. So there's 3 non-bank markets that automatically fall within the Bureau's supervision, regardless of size. Anything in the mortgage world, private student lending, and payday lending. Those categories of non-banks are all subject to the Bureau's supervision authority under the Dodd-Frank Act. But the larger participant rulemaking is something that's different. It was previously housed in supervision. It's now housed in the rulemaking office at the Bureau. And it's very interesting to kind of watch how the Bureau goes about, number 1, defining a market, and number 2, promulgating a rule that subsequently says this is the kind of conduct that is within or without our jurisdiction. And so I just wanted to take a step back and make sure everybody on the call understood that, larger participant rulemaking isn't quite the same thing as the substantive prepaid card rulemaking, although it's coming out of the same office now.
Thanks. It's always great to get that kind of inside perspective. I'd like to jump just to the other expected developments for the next few months in 2 really kind of big areas. The payday lending proposed rule, which we're expecting to come at some point this spring, which has certainly been a priority for the Bureau, for a lot of other federal regulatory agencies as well. The Bureau has previously held a field hearing and issued, guidance on the payday lending market, and no one knows for sure what the proposed rule is going to have, but I think you can pretty much guarantee it's going to have a focus on disclosures, on issues related to ability to pay potentially, the practice of rolling over some of these loans, to have kind of a continuous cycle of payday loans that a consumer may find themselves in, which is a big issue that's been raised by consumer groups, and now that the Bureau is very focused on as well.
And there's a real question here too, is that, not only how far the Bureau wants to go, but also competitive issues too, between banks and non-banks and others who may or may not be involved in the small dollar lending, short-term loan space now, and whether or not this will level the playing field, or if this is going to, inadvertently, create some folks that may view it as a positive or not. Andrew, in the debt collection space, the Bureau has enforcement authority over the Fair Debt Collection Practices Act, but that's not the only place they're looking at debt collection practices, is it?
No. Well, they issued an announced notice of proposed rulemaking a year or so ago, and this is the first time that a federal agency has really been issuing these kind of rules. And it was the proposed rules that they issued had hundreds of questions that kind of covered all aspects of the debt collection market. They asked questions relating to third-party collectors, debt buyers, first-party, collections by first-party lenders. Just really every aspect of the debt collection industry they collected information on.
Which are all areas that we've seen enforcement or supervision/enforcement work too. In fact, actually, arguably there hasn't been a pure debt collection enforcement action yet. It's all been folks that have either been first-party lenders or private student loan lenders and others, including even like furniture stores.
Well, what's interesting about that is when you've seen the enforcement actions that have involved concerns about debt collection, those have generally been brought under the Bureau's Consumer Financial Protection Act, UDAP authority, not necessarily under the Fair Debt Collection Practices Act. And there's definitely overlap between those 2 authorities. It's not exactly clear where one ends and the other begins, or how they relate. But the rulemaking is certainly going to be taking kind of a look at that and establishing concrete rules for the industry for the first time.
Well, it's the first-party, third-party issue, isn't it? I mean, so some of what we're seeing in the debt collection enforcement arena is we're seeing first parties being held accountable for the way debt collection is being done, either by their companies themselves or by vendors. That's something the Bureau can regulate with its UDAP authority, but the FDCPA, the Fair Debt Collection Practices Act, is a third-party.
That's right.
And so I'm curious if you can talk a little bit about what you're seeing in that world, Andrew, and what's proposed in the advance notice of proposed rulemaking, first party versus third party, because this is a real parlor game here in D.C. where people are trying to figure out if this is going to impact first parties and not just third parties.
Well, there certainly was a lot of pushback to the proposed rule by by the first-party industry, to use the term, in terms of the comments that they submitted. They don't think that the proposed rule should govern first-party collections. They cite to the fact that the FDCPA really doesn't apply to first-party collections. But on the other side, there's a lot of folks that think that this proposed rule will use their general UDAP authority to also cover these first-party collections. And I think if you look at some of the enforcement actions that have relied on that general UDAP authority, the concerns and the practices that they addressed are the kinds of practices that are already covered by the Fair Debt Collection Practices Act for third parties. So you really do, even though there are two different authorities here, it's a lot of the same acts and practices that are being looked at by the Bureau.
And for a lot of first-party lenders or quote collectors, this is going to be a very new rubric for them. And there's also a bit of a square peg and round hole where you've got very specific rules and case law that's been developed over a number of years in the debt collection space, now sort of imposed upon a world that has not previously had to address that. It'll be very, very interesting to watch develop, and also to see in 2015 too if companies challenge some of the Bureau's assumptions and expectations about what the practices should be in that space. Now, Randy, the Bureau has been focusing in the enforcement setting, but also we see it across the board, and even in our practices when we're dealing with product development, when folks come to us and say, this is what we're thinking of doing. The threshold question really usually is always, well, what's going to be consumer facing? What's the consumer going to see? And how is the Bureau going to interpret that? And part of it's marketing and advertising, and some of it is the more substantive what's behind that. But the two are very interconnected.
Yeah, Jonathan, I think that's right. And I think some of the problems here too result from a lot of the industry's companies that are being regulated by the CFPB haven't traditionally been regulated, or sometimes they are, but not very heavily, by the FTC, and so they're not terribly familiar with how the CFPB is going to look at their advertising and marketing materials. And as Allison said earlier, they've been flexing their UDAP muscle. I think we all expect they're going to do that even more in this coming year. And they were created to be like the FTC, but not quite. And there's some significant differences, and I think it'll be interesting to see how those play out over time. As Alex mentioned, the CFPB has supervision, examination power, so they can really get into your documents, into your inner workings, simply by virtue of their supervision, examination power, which the FTC can't. The FTC has to have a reason to believe that you're misleading people, that you're engaging in deceptive marketing before they can show up at your door. They can't just show up unannounced and say, let me see all your documents and talk to your people. And they've also got the abusive authority, which, Director Cordray doesn't quite know what it is, but he'll know it when he sees it.
They've seen it. Not knowing what it is, I think, is a bit of a farce.
They've seen it. I think they'll continue to see it. And it's interesting because, and you see some of this in the proposed rulemaking that Andrew talked about, there's this notion here that, to some extent, marketers, advertisers have to look out for the welfare of the people they're marketing to, that consumers are entitled to rely, to some degree, on the fact that businesses are looking out for their best interests and not just the best interests of the business. And that also is a pretty significant difference from the FTC.
I don't think that's what they teach in marketing school.
No, well, not yet. So I think in terms of things to keep an eye out for the next year, obviously the CFPB and the FTC were created to overlap to some degree. The FTC just celebrated their 100th anniversary. The CFPB, I think they've been around for 3+ years. So far, the coordination between the two has been pretty seamless. I think we're only aware of one investigation where there was some duplication between the two, and that got kind of resolved. But I think everybody kind of expects that those problems are going to grow, particularly as the CFPB begins to expand the scope of its work. And Jonathan mentioned the recent action against Sprint for third-party cramming, which really very closely mirrors what the FTC has been doing in that industry. And so you've got a lot of potential here for differences in terms of standards. We've already seen differences in injunctive relief and compliance provisions that the CFPB favors versus the FTC. And so there may be some pressure from industry for the two agencies to more closely harmonize. In terms of how the CFPB is going to look at your advertising, just very briefly, I think the key thing to remember here is they're not going to care what you think you're saying in your marketing materials or in your advertising. You may have all the good intentions in the world, but they're going to look at it through the eyes of a reasonable consumer and more likely really through the eyes of the CFPB staffer. What do they think you're saying, not what do you think you're saying. And bear in mind, too, if you're dealing with financially distressed consumers, they're probably going to dumb down even further kind of the reasonableness of any interpretation of your advertising because they view those folks as being particularly vulnerable. And so you have to worry about what your advertising literally says and make sure that's true. I mean, some mortgage lender got tripped up recently. They sent out a letter to the loan holders promising the return of excess escrow funds. Well, they also sent that to delinquent loan holders. They obviously didn't intend to return those funds to the delinquent folks. It probably wasn't very reasonable for those folks to think they were going to get that excess escrow back, but the letter said they were going to do it, and the CFPB held them to that promise. But apart from what you literally say, you've also got to worry about what you're implying. It's not enough to say it's literally true. You also have to worry, for example, with the credit card add-on products, the CFPB essentially said that by offering them to consumers, you were implying that they were also eligible for the benefit. So you couldn't offer consumers who are already unemployed a job protection credit card add-on that they weren't eligible for because they didn't have a job right now. And I think the other thing to watch too, the FTC has managed to persuade courts that because of their experience, because of how long they've been doing this, they should be entitled to deference. They can come into court and say, we think this is what this advertising means. The CFPB is now beginning to kind of make that argument in some pending cases to say, me too. We should be entitled to the same deference the FTC has had as far as interpreting advertising, and it'll be interesting to see how courts handle that given the newness of the agency. In terms of kind of specific areas to look for, I think you can kind of watch what's happening generally in the realm of advertising and marketing regulation. So disclaimers are a very hot topic. There's been a lot of discussion here already about different rulemakings and other provisions that involve kind of beefing up disclaimers. Financial product services companies have been traditionally pretty heavy users of fine print disclosures, but the trend is really moving further and further from using disclaimers and instead saying, look, why can't you put at least some of that fine print into the text? Or arguing that a disclaimer can't contradict. You can't say in the text, get something for free, and then in the disclaimer qualify that by saying, well, you actually have to buy something first. And also in terms of the clarity of disclaimers and the conspicuousness, there's been much more emphasis on that.
And Randy, with the disclaimers too, there's the potential that the Bureau is going to come out essentially with disclosure requirements in certain areas. Essentially, in some cases, they already have or suggested that there should be certain form documents and stuff be used. How would you say that disclaimers and disclosures, how does that go hand in hand, or does it?
I think a lot of times the two are synonymous. Some people say, you say potato, I say patata. So I think disclaimer, disclosure often can mean the same thing. I think one difference is the FTC has traditionally been reluctant to kind of say this is how you have to disclose something. They haven't liked to have black letter rules, which I think some people in the industry would rather have. There's a certain clarity to knowing this is exactly what size font I have to have it in, and this is exactly what I have to say. So I think if the CFPB moves more towards a model of saying, this is a mandated disclosure, or this is how big it has to be, or this is the form you have to use, that may, in some instances, help. In other instances, it may
right.
hurt.
And like there's the CFPB Project Catalyst and the no action letter rubric that they've come up with. Some of those may be of some limited utility, but it suggests that there's an ability for companies, if they wanted to stick their neck out, to essentially test with the Bureau certain disclosures/disclaimers and affirmative information they might want to provide to consumers.
There's also a disclosure safe harbor provision in section 1032 of the Dodd-Frank Act that allows for companies that are using the specific disclosures that the Bureau puts out to essentially have that safe harbor, assuming those disclosures are done in accordance with what the Bureau expects. For example, the know before you owe disclosures or the prepaid card disclosures. But that doesn't completely get around the question of how you market your product, does it, Randy?
No, because you're still going to be making lots of claims, presumably, that aren't covered by some sort of mandated disclosure provision. And so you're still going to have to wrestle with, how prominent does it have to be? Is it a disclosure? Is it in the text of the claim? And even some industries that I think have traditionally felt like they were kind of immune from a lot of scrutiny in this area have come under the microscope. Both the CFPB and the FTC are both looking at the auto industry, both in auto lending, and the FTC is going after auto dealers for their disclosures. I think traditionally people have kind of seen those ads and sort of laughed at how bad some of the disclosures are, but no one's ever done anything. And so some of these industries that have kind of felt like they weren't under the regulatory microscope are suddenly finding themselves, very much subject to it. The other area that I think has really come under a lot of scrutiny, and that is the other key thing to watch, is the continuity auto renew type programs, and there are, again, a number of these in the financial services area. The FTC just brought a case against a company offering a free credit report, and there was what came with that. The catch was that you were signed up for a continuity monthly auto renew program. And so there's really an emphasis, again, on making sure that that's disclosed prominently, that you actually get affirmative consumer consent. There's a checkbox or some way people are actually affirmatively consenting to it. And then you also communicate very clearly to consumers how they can cancel if they decide they don't want to continue in the program. So I think that's another area that's used pretty extensively in the financial services area that's also likely to be the subject of a lot of enforcement scrutiny.
Yeah, and Randy, this applies to not just the folks who make or offer products and services in the first-party context, but also to those that advertise on their behalf, service providers. So if you're just an advertiser or a lead generator in some cases, all this is still very relevant, right?
Yeah, and again, I think it'll be interesting to see. The FTC has certainly been expanding the universe of parties that can find liable for facilitating, assisting, providing means and instrumentalities for deceptive or false advertising, including affiliate marketers, advertising agencies, payment processors, fulfillment houses, and it'll be interesting to see to what extent the CFPB kind of goes down that same path.
I think we can expect that they will. Their service provider jurisdiction, their related person jurisdiction, and their substantial assistance jurisdiction all kind of allow for an enlargement of their kind of core covered person jurisdiction. And what I mean by that is service provider, if you're a third-party vendor and your third-party vendors engaging in conduct that the CFPB believes is problematic, they're going to hold that vendor accountable, but they'll also hold the company with which the vendor is doing business accountable if the company is within the Bureau's jurisdiction. And I think a lot of what we saw early on with some of the UDAP marketing cases that you've discussed were in fact service provider marketing efforts, and the Bureau didn't really make a distinction. They kind of held both parties accountable, or they said the core party's accountable, notwithstanding the fact that it's your vendor doing that. And akin to what the FTC has been doing for years, and I think we'll see the Bureau increase its jurisdiction in that way as well.
Yeah, I mean, I think it's almost impossible to resist the temptation of doing that because you basically expand your enforcement resources by making sure that other people in the industry are kind of doing part of your job for you by scrutinizing the vendors they use.
Absolutely. I think that's the beauty of it, right, if you're the enforcement people.
Randy, if folks want to take preventive steps, training and customer interactions, remedying the problems and stuff, all very relevant. What have you seen? Have you seen the CFPB respond to that differently than the FTC has, or is actually the CFPB is almost more prone to respond to the evidence of this than the Bureau, than the Commission?
Yeah, I think again, it'll be interesting to see how they evolve over time. I think the FTC has kind of evolved to a point where they want people to fix their problems first. Again, that helps from a resources enforcement standpoint. If they can get industry to fix their problems before the agency shows up, they want to reward that because, again, that removes an issue the FTC might never even see. I don't think the CFPB has yet kind of made any public pronouncement on whether, how they would interpret a company that finds a problem and fixes it before the CFPB shows up with a subpoena or enforcement or supervision team. But
yeah, I mean, they've suggested that you'd get brownie points, but I don't think we've seen that. We haven't seen that manifest itself in that manner yet. In fact, we've seen almost the opposite, which is companies that follow the remedial action bulletin and end up in the same soup as essentially, at least their perception is that they end up in the same soup as they would have if they hadn't taken those steps. It's that precautionary principle concept at play again.
But that's the enforcement versus supervision arenas. I think in the supervision arena, you probably do get real, actual browning points for, remedying a problem before it blows up. And those are confidential, and so we aren't going to hear about those writ large. And in fact, if you read some of the supervision manuals or examination reports, you'll see a few oblique mentions to that. But yes, absolutely. I think the public enforcement actions haven't necessarily borne out to be, we're going to give you extra credit for coming forward and identifying a problem and then fixing that problem, and query as to how that will play out in the future.
And John, before we wrap up, just wanted to, circle back to where we started at the top of the webinar. We said, we have a new Congress in session. The Senate has flipped to Republican majority, and the CFPB and Congress have butted heads before. What do we expect to see in 2015 and beyond on the legislative front?
Yeah, I think there's a couple different areas. There's structure and authority, and there's efforts on single issues, Alex. And, on the authority, the big question really is will Cordray stick around through the first year of whoever the next president is, and what's going to happen in between with respect to the structure of the Bureau, whether or not there'll be efforts to reform it, and whether or not those positions on reform change as it becomes more clear what's going to happen in the 2016 election cycle. We've got a presidential election coming up in 2 years, and there's also the potential for a Republican president and Republican Congress. Will Democrats want a bureau that could be run unilaterally by a single Republican in roughly 3 to 4 years? That is going to be an issue that is going to be increasingly of mind. You've got also on single issue areas, with a Republican Congress, there's the potential for otherwise must pass legislation that, but there's also the potential for incremental reforms in areas like, for instance, the Fair Credit Reporting Act, Fair Debt Collection Practices Act, and actually some statutes that the CFPB does not have authority over yet. But like the Credit Repair Organizations Act, there's routinely amendments submitted in Congress and in other statutes too that are consumer protection oriented. And so while there may not be efforts to add more stuff to the CFPB Christmas tree of statutes, there may be efforts to tweak the statutes that the CFPB or the FTC or others have authority over. So as that manifests itself in the next 2 years, certainly folks will want to watch for that and perhaps be players in that debate. From additional resources for folks on the phone, as part of these slides, we have a number of checklists available. And so there's also, in addition to these checklists, a number of articles and presentations that are going to be part of the related materials, particularly for CLE requirements, that are going to be posted on the web and attached to the email certificate information that's going to be sent out for folks doing CLE. We've now come to the end of the presentation, and I do see that there's a couple questions here. I guess just to do a quick round robin, one thing you expect to see in 2015. Allison, first you.
I think you will see the Bureau focused a lot on ability to repay or pay for products or credit that gets offered. I think that's going to be a huge focus in the enforcement, supervision, and rulemaking realm across different financial services sectors, so stay tuned.
Andrew?
I think with some of the upcoming rulemakings and the comment periods are coming in, you're going to see some very strong responses from industry. And so it's going to be interesting to see where some of these rules end up, the final rules versus what was actually proposed by the Bureau, to start to see how does the Bureau actually take into account the feedback it gets from industry as it goes to a final rule.
Randy?
I'd say more cases like Sprint, where you see the Bureau try to expand pretty liberally its definition of financial products and services.
Alex?
Yeah, similarly, I think you're going to see more litigated cases. You're going to see settlement talks break down and the parties going to court.
Yeah, and I think you'll start to see more questions about whether or not the Bureau needs to be reformed, structure, as well as also the statutes to come in line with the regulatory rulemaking authority and to take into account now this new supervision and examination environment that banks and now a considerable number of non-banks fall under, as well as also, of course, the overlap with the states. So, folks, stand by for today's CLE code. And also, too, just a reminder that a recording of this presentation and other materials, articles, presentations on related topics are available at venable.com /CFPB/publications.